Scott asked a really good question in the break, so I didn't answer him. I thought I'd answer you all together. So the question that he asked was about Turnitin and similarity scores. How worried do you have to be? I was tempted to say worry, just worry, worry, worry. Don't worry. Okay, when you need to worry about Turnitin is when you have cut and paste stuff from websites, example essays, or borrowed a surprisingly similar assignment from somebody else. In other words, if you're cheating, or if you have bought an essay from somebody else who might be cheating, you need to worry, okay? Worry big time, probably don't submit, go home. If you are not in that situation, which I very, very, very much hope you aren't, a high Turnitin score will mean one of a number of things. One is often he or she who submits early will always get a lower Turnitin score than the person who submits half an hour before the due date. This is because it's just a computer, right? It's just comparing stuff in its database. As soon as your stuff goes in, it's got the party names, it's got bits from the question, there are all sort of things that keep overlapping, so necessarily the scores are likely to be lower for earlier people than for later people. Secondly, AGLC 4, for that matter 3, 2 and 1, do not play nicely with Turnitin. Turnitin it's a computer program, right? Its algorithm is designed to find quotations and then see names and brackets in standard kind of forms. In particular, it will treat quotations as things that sit in quotation marks. But what does proper use of AGLC4 say? If you've got a long quotation, it doesn't want quotation marks. It wants you to do it differently from that. And then some of the things, sometimes it uses single quote marks. So often people who have done really well with their AGLC4 will get a higher score than somebody who has done badly. Sometimes it will be because you have paraphrased or taken words from judgments. Interestingly enough, I don't know if I should tell you this, but my experience is that Turnitin is not very good at finding case law. So when people have taken, cut and paste things straight from the cases in, Turnitin might not pick them up. The thing is, the people who are most likely to do that are people who are, and actually also our textbook, by the way, they are very rarely people who have gone and done huge amounts of research elsewhere. And so chances are, if it's a case, remember I've been teaching this since 2012, it's a case that I've read twice a year, or at least skimmed over twice a year since 2012, chances are I'm going to pick it up. So yeah, again, you might get a brilliant score on Turnitin, but you could be riddled with bits from cases that I'm going to pick up anyway, right? Because that's who I am. So Turnitin is a very blunt instrument. If you get a yellow or a red indicator, that means it's higher than what Turnitin normally says. The yellow or the orangey ones are rarely problematic for law students because of the nature of how this works and the nature of the type of assignments that you're doing. When you get the score that's like that, I would go and have a look at the report and satisfy yourself that you haven't omitted a reference or dealt with something, because it's going to pick up things that need referencing that you've probably already referenced, right? If it's red, you definitely want to do that. The thing is, when it's red, chances are that that you haven't got enough time. So that's the other problem that you have. So remember, you can submit for Turnitin checking purposes every time. And by the way, you don't have to tell me that that's what you've done. So sometimes people put them in for Turnitin and then they leave a little comment just for Turnitin or still a draft. I learnt that the hard way. I don't start marking them until after the due date because I've thought, oh good, I'll get a head start on this and half-mark somebody's draft, and then turned everything off so nobody else could get in, and it was all a bit of a disaster. So I won't do that. I don't need to know. I'll just mark the most recent. Does that answer your question?
The last question is normally, do we just have to, worry if like a certain score or something like, more than probably 70%?
No, it's a blunt instrument. So a certain score,
100%?
yeah, 100%, definitely. 50%, that's going to be red, and I would be looking, but it might be absolutely perfect at 50%. And it's picking things up because your AGLC referencing is perfect. It's not designed for law papers, but certainly if it comes out orange or red, I will definitely look at it. I'll go and look at the report. And even if it's green and it just feels funny, I'll look.
So that means if I just get some information from the internet, but I set that up properly, like the reference is still okay. But
yep. So again, if you've taken something, if you're directly quoting, then we need a reference. If you're paraphrasing, we need a reference.
Yeah.
If you're crediting that person with the idea, well, if the idea has been inspired, we need a reference. When in doubt, put in a reference.
So that means, if the reference is properly, so even
yeah.
if the thing is true.
Yeah, so Turnitin might tell you that you're 75%, but if you've quoted it properly and whatever, you'll be fine. Now, again, at 75%, you might have great quotes in there and all perfectly referenced, but that doesn't leave a lot of room for your own opinion or anything of your own either. So I'm not going to say you're going to get an HD if you do that. It's just one of the tools that we use. It can be a bit of a blunt instrument.
Thank you.
Okay. So we're on the home straight, my friends. This week and the two that come after it, we are effectively looking at one theme, the contents of a contract. You have got yourselves to this point that you should know what we need to do to form a contract, and you've got some understanding of some vitiating factors, some things that can affect the enforceability of a properly formed contract. So now we've done all of this talking about whether a contract's been made or not made, etc. But the question that we have only skirted around the edge of is, well, what does the contract actually say? How do we work out what the terms of a contract are? And ultimately, we're going to do that over the 3 weeks. And I hopefully have warned you in advance that this 3 weeks might go backwards and forwards a little bit, that we might not just do, topic 9, topic 10 and topic 11 tend to blend a little bit. And at this point, I should say, for those of you who are concerned that you didn't find the desk lectures, that's because they don't exist. And I did what I tell you guys not to do all the time. I have to write or have to prepare desk lectures for week 9 and week 11. Only 2, lots. 2 of my favourite actual topics. And I left them till last Thursday. I'd blocked out the whole day to do them. And I was as sick as a dog under the doona. And my plan is now to try and start them tomorrow, but that will depend very much on how my voice is. It might be Wednesday or Thursday before I can get to them. So not ideal, but hey, we will get there. And if we have to do longer tutes, we will. Can't work out what, oh, here it is. So this section, what we're exploring over these topics is how do we work out what the terms of a contract are? How do we read or understand? The language I'm going to use is construe a contract. So we construct a contract, as in draft a contract, prepare a contract. We construct, and to understand it, we construe. To make sense of it, we construe. So terms, we're going to do that by looking at where the terms come from. So today and into next week, we'll be talking about express terms. And then we're going to move into implied terms. Then in the final week, we're going to do a deeper dive into the understanding, and we're going to do that by examining a particular type of clause, a disclaimer or exclusion clause. So the types of clauses that create in our private law between parties limitations on the liability of a party or the extent to which a party can be sued under a contract. So this is today. We're going to talk in the overview, we're going to talk about the express terms, and then ultimately we're going to think about this from 2 points of view, the lovers versus the fighters. So up from the very beginning, I've told you I am a lover. I am not a litigator. I am a transaction lawyer. I write contracts for a living. That's what I think is the fun and interesting bit, particularly when you get a blank sheet of paper and it's in an industry that is new or a situation hasn't been done before. But we also have to think about contracts from the point of view of the litigator. So understanding how a contract is formed and understanding what a contract means and how to read a contract is absolutely important, critical even, to the contract litigator's role. Because they will, if you've got and think about the cases we've done over this semester, most of them at the end of the day, we've got one or more parties who either don't want to do what they're been promised, or are trying to make somebody else do what they were promised. So all of the cases about how a contract is formed come out of disputes between parties where at least one of them doesn't want to be held to account. And that's because clever litigators have found these different ways of addressing these kinds of problems. So for those of us who are transaction lawyers, we're on the other side of that strategy. We're trying to think about ways in which contracts haven't been upheld to make sure that the documents that we write or the way we advise our clients to get into contracts doesn't fall foul of those things. And this exercise that you're doing as a second assignment falls absolutely squarely into that space, right? You are going to draw on all of the things that you have learnt so far to think about what the contents of that contract should look like. So, again, at risk of going on, this is how the plan for the semester worked. We started off with the elements with that question, do we have a contract? We thought about formation, the matters affecting formation, so we could ask, if we do have a contract, can it be enforced? And now we're at the sticky end of the semester where we work out, well, what actually does the contract say? If we've got a contract, what does it say? How does it work? So all of these sections are aimed at understanding, identifying the express terms. So terms in contracts tend to be classified. We're going to do a lot of classification today. We tend to think about the terms in a contract as either express or implied. Most contract terms will be express in some way. And so we're focusing today on where they're expressed. Now, clearly, if you've got a written contract document that has been signed by the parties, it's pretty obvious that that document will include the express terms. The question then becomes, are they the only terms? Was there some sort of communication outside of that that was intended to be part of the contract? Then we've got implied terms, and implied terms come from a number of sources. The law implies some terms. We might get terms that are implied out of parties' behaviour, but we'll go through that. We'll start on that next week. We've done a little bit of this idea of gap filling already when we talked about certainty, but in a way this is like an extended deep dive into that certainty area, that we need to identify whether there are any gaps and whether those gaps can be filled. Can they be filled from something that's implied at law, in fact, or by custom, or do we pull them in some way from the conduct of the parties? So, when I was planning out, this is literally from my plan for this part of the subject. I can take mapping things out to a whole new place of geekiness, but what I want you to see, I don't have my fancy clicker today, but it's kind of colour-coded. So the green stuff is all about what the terms of the contract are, the express terms are. Then we're going, so we've got express terms and a little bit of implied terms as we move in there. Then we're going to talk about the purple stuff, which is construing the terms, and then we will talk back into the moving into the gap filling, and come back then into pulling all of that together by talking about it all in the context of disclaimers or limiting terms in some way. Which reminds me, my big map of how this course works, which I update every 6 months or so, is actually available to you in Canvas. It is messy and disorganised. It is literally a window into how I think, but it has a lot of stuff in there that many students find quite useful at this end of the semester as you're trying to start to get ready for the exams in particular, because it links the cases for each topic. If you go into the revision materials in the week 12, you will find 2 links. My memory is there is one which is the one I would use, the online open bits and pieces, but I have also just spewed it out into a nasty long Word document. It's not pretty, but it's got a lot of stuff in there. You might find it helpful. If you don't find it helpful within about 5 minutes of looking at it, I would put it away and do something that you do find helpful, all right? All of us think differently, but it's there for you if you want it. So, what are we here? Why are the terms important? Ultimately, because the terms set out what the obligations of the parties are and what the rights are. And there is a particular voodoo magic to the way that courts read contracts, which as lawyers we need to keep in mind when we're talking to our clients about what their contract means. So, where do we find the terms? The terms are found in the communications between the parties. Clearly, it's, as I mentioned before, it's really easy when you've got a written document, particularly when that, well, mostly, when that written document has a provision in it. Often it'll be called, excuse me, sorry, I just did that so hopefully I can find it and take those bits out of the recording, because that's just going to hurt somebody's ear, me coughing into this thing. If you've got a written document, it's signed, and you have an entire agreement clause, or a clause, they're sometimes called entire agreement or exclusive agreement. So often documents will actually, the contract documents will include a clause that says this is the entire agreement between the parties. No, any conversations or negotiations or discussions we had before we signed this document is either recorded in this document and replaced by that, or it just means we didn't reach agreement. Okay, so often that makes it really easy to say this is what the agreement is, nothing else applies. Although, and we will look at a couple of cases that deal with this, particularly in a consumer contract point of view, the legislation has something to say, particularly if the terms are onerous, but we'll get to that in week 11. Other places where you can find terms could be in the negotiations, the conversations that people had. They might be in some sort of informal written sense. They might be on Facebook, on Twitter, on Grindr, on Tinder, on Canvas. They could be anywhere. They could be incorporated in a ticket, on a sign. The cases that we're going to look at over the next 3 weeks will make you anxious about parking lots, going on cruises, or taking things to be dry cleaned. Because tickets and receipts and signs are a place where we see contract terms all the time. And it could be some combination. It could be it could be oral, it could be partly written, partly oral, it could be a sign, a conversation, a receipt, and terms and conditions on a website. They could be in all sorts of places. And then, of course, we will move on to the terms that are implied by law itself. So we're going to talk today about recorded terms, express terms, and we'll move on probably in the second half of next week on to terms that are implied by statute. So, how does the court determine which of the many communications between the parties form a contract? It takes into account a number of different things. So this week we meet a friend to us all, the parole evidence rule. We'll talk about that a little bit further on, and we'll probably do a deeper dive onto it next week. But the parole evidence rule is effectively the trump card of communications. So the parole evidence rule effectively says that if there is a written document which appears on its face to be the entire agreement between the parties, then no evidence that contradicts those terms will be admitted into court in relation to any dispute between the parties about that contract. So effectively, something in writing trumps something that was said earlier. Something that is in writing might, however, in certain circumstances, be amended by something that is said later. And again, sometimes to avoid confusion about that, a contract might say, if we're going to change the terms, the only way we can do that is by us all agreeing and signing a document that says so. Plain English, there you go. So let's just have a look at some examples as we move forward. And let's start talking about let's have a break and come back and talk about express terms, because I want you ready for these dry cleaning and parking cases. Okay, you at home, take a break as well.